Good evening, ladies and gentlemen. Welcome to the Hong Kong branch of the Institute of Chartered Shipbrokers and Indian Maritime University's pre-webinar, Hedging Losses and English Law, Guidance for Shipping Professionals. We have an absolutely fantastic panel with experts from the commercial field as well as from the legal field. And I would like to welcome my panelists. Thank you very much for joining us today. I'll be introducing the panelists in a short while. So what we are going to do today is basically look at the commercial as well as the legal aspects. Hedging, when we talk about hedging, if there is no basis risk, if it is something which is back to back, then hedging becomes just like a process. It's not very difficult to do. But many businesses, especially in shipping, when we are looking at the different routes, Baltic Exchange cannot have hundreds of routes. So you have different routes and you may not get exactly matching liquid index where you can do the hedging. So there are some issues. And we are going to listen to our friends over here on the panel, Alessio La Rosa and Captain Patnaik, that how they do this risk management in their companies and what are the issues that come out of it. Disputes will happen, contracts breaching will also take place. And that is something, even if we do everything under the sun possible to avoid that, these things do happen. So how does the English law look at the hedging losses? Suppose somebody has taken a position and the counterparty has defaulted. In addition to the standard usual way of calculating the loss for the claim, there could also be a parallel loss which comes out of the hedging loss. Of course, they cannot duplicate itself. Hedging and physical, you cannot have X multiplied by 2. So we are going to see how whatever legal professionals on the panel tell us, how does the English law looks at it and how do they look at it? Now, before we go ahead, move further, let me quickly introduce to you our commercial experts and then the legal experts. Alessio La Rosa is the fellow of the Institute of Chartered Shipbrokers and is the global head of freight in COFCO International. He is based in Geneva. Captain Soumya R. Patnaik is based in Dubai and is the chief executive officer at the International Shipping and Logistics. It's a Tata Group company. And our legal experts are Ms. Sarah Hunt. She is a partner at the Holman Fenwick Villan, and she's based in Geneva. Mr. Ian Sharp is a partner at the Hill Dickinson in Singapore, and Mr. Prideri Deepschlag is based in Hong Kong, along with me. I am based in Hong Kong too. And Prideri is a counsel at Clyde & Co. Now let us first begin with our commercial experts. Welcome, Alessio and Captain Patnaik. We know the commercial trading and shipping is a very volatile business, which is ridden with market, execution, operational, and of course the credit risk. And that provides multiple challenges in the road to profitability or a successful business execution. Can you give us an overview how you navigate around these hurdles and in terms of hedging, whether it is physical hedging or it is derivatives hedging, is that an important part of your risk management? I would also suggest, for the benefit of all our participants, if you could throw a little bit light on how you go about doing this hedging. Because as I mentioned earlier, there could be basis risk, there could not be back-to-back physical and derivatives, zero basis risk, not possible. So let me start with Mr. Alessio La Rosa. Alessio, would you like to go first, please?
Sure, Jagmeet. Thanks for inviting me to this panel. Good morning, afternoon to everyone who's listening us. I hope to be as quick as I can. But in essence, yes, in a real world, for every single physical transaction, there should be a linked hedge going with it, assuming a company wants to run a flat exposure. In more often, in our case at least, with a huge volume, we would need an army of accountants to have that in line. So everything falls into one basket, whether it's cargoes, whether it's FFA or ship. At the end of the day, what we try to achieve to manage the risk properly is to have what is our flat our exposure in days equivalent. So that's what we aim to. So in case of default, so one of the counterparty, well, as we know, there is no any more problem with the OTC because all is clear on the FFA. So that part is clear, but on the physical side of it, if there is a default, then I think it's difficult for us to evidence the case, and I would like to hear from the lawyer on the panel what is the best approach to that. But overall, in our history, we spend a lot of time and efforts on the credit risk. So in my experience, we try to do whatever is best process in our view to prevent those cases to happen. And I think a proper diligence helps that to happen. We know that in shipping, unfortunately, when a company goes bust, and there are many other surfacing the next day, so it's very difficult to control more on the smaller size than on the bigger size. But there are big players, and it's more consolidated environment. But on the smaller side of the supra end, these tend to happen sometimes. So we try to regulate that with the proper process in place, but we know that the credit risk, counterparty risk is clear. We need to manage that properly in order to avoid those circumstances.
And thanks a lot, Alessio. Now, before I go to Captain Patnaik, just very quickly, you talked about the trade book, and you said
Yes.
there is cargo, then there are ships, and there are FFA. So everything you crystallize in terms of tons or in terms of number of days? So
number of days, as I said, we convert everything into days equivalent, as I mentioned before. Okay. So whether it's ship, whether it's FFA, because it's easier to link with the Baltic index, as you know, and therefore we have a proper system in place that updates the values on a single day, so we don't have to do that manually. It's an automized system for us. Right. So the only thing we do, basically, we translate the volume tons into days. Basically, we convert the cargo exposure into days. So otherwise, ships are in days and FFA is in days. What we do is to convert that in cargo in days. Of course, there is a bit of discrepancy because not all the routes are clear in the index reporting. So we apply some certain factors that we review on quarterly basis. But clearly, there is a human impact when we apply a factor versus a certain route, right? So,
right.
But we are able to.
Right. Thanks a lot. We lost Alessio. So Captain Patnaik, can you go ahead, please, where Alessio left? Yeah, thank you.
Yeah, good afternoon, Mr. Jagmeet and my fellow panelists. Good morning, good afternoon to all the audience who are there hearing us. So yes, you are right by saying that shipping is a very, very volatile business. And one has to be very careful on various aspects of doing shipping business. The risk can be counterparty risk, market risk, operational risk, changing rules very frequently. So there are many risks that are there. Since I represent from an operating company and ship owning company, and unlike Alessio, who represents more of a cargo desk. So we look at risk from an owner's point of view. And it is important to have risk hedging as one of your main activities in doing business. Now, risk hedging is a very broad subject. You can either do a physical hedge or a paper hedge, but we are more into physical hedge than paper hedge. But yes, we do have great amount of understanding on paper hedging. Now, physical hedge is very simple in the sense that you take a vessel against a COA that you have taken to perform. So primarily the risk aspect comes in when you take a long-term position. When it is spot, booking a cargo 10, 15 days, 30 days ahead, then you are more or less sure what the market is. But when you take a long-term position, let's say 3 months, 6 months, 9 months, 12 months, that's where people should not speculate about the market. Generally, people go wrong when they try to speculate the market or make their own assessment of the market, which is not correct. So I think that's where hedging comes in, and it's a prudent practice to do proper hedging. Even hedging also has to be done correctly. You cannot also have little knowledge about the hedging mechanism and then get into doing hedging, whereby you tend to lose more money in hedging than what you would have actually lost in physical. So that's again, people make a lot of mistakes. So very important is knowledge about the subject when you get into hedging. So coming back to physical vis-a-vis paper. So paper hedging, as you rightly said, it has to be done against the standard Baltic routes. And there are certain routes which are more liquid and certain routes which are not so liquid. So you have to also understand which route you have to follow. If you don't have clarity in the route or the liquidity, then at least you go for all TC routes, whether it is 5 TC for Panamaxes, 10 TC for average for Supramaxes, but go for all 4. Then apply the correlation. Suppose you are doing a particular route where you do not know, you do not have a particular Baltic route associated with that, then you apply your correlation factor. If the correlation is 90%, then you apply that to your hedging and then take that as your factor. So correlation factors are available, which are industry benchmarks that are there. You can go for that. But the advantage of paper is that you have a lot of flexibility in doing paper, unlike physical, where there are a lot of operational risks like vessel missing laycan or operational issues, off-hire. Those kind of risks are not there in paper risk. Paper risk are very simple. You can close the position whenever you want and highly flexible. And there is no counterparty risk. Unlike period charter, there is counterparty risk. The owner defaults, then there's a big risk there again. So there is no counterparty risk because you'll be doing mostly through exchanges. And so exchange takes and exchanges are very, very reputed financial houses where you don't land up in a counterparty risk. And since you asked me to give some nuances about how it is done, so generally the hedging mechanism is reverse of physical. That is, if you are selling freight physically, you have to buy paper, vice versa. So that if I'm signing up for a period charter, then I have to sell paper, or if I'm signing on for a COA, then I have to buy paper. And as Alicia rightly said, it is for number of days, not for the cargo quantity. So if you are taking a position on a COA for 90 days or 120 days, it is expected that you buy paper for 120 days. So that's a good likewise risk management. So then second is that this can be done by anybody. An owner can do it, operator can do it, cargo trader can do it, exporter can do it. This is a tool which is available. You need not have a shipping knowledge to get into FFA. So anybody can do try and get into this. It started with over the counter, but now I think exchanges are becoming very popular. So for freight market, you have the popular exchanges are EEX, which is the European exchange, and SGX, which is the Singapore exchange. And for bunker, it is your ICE in New York and CME, which is your Chicago Mercantile Exchange. So they are very popular and they are very reputed. So you avoid your counterparty risks. And generally, you have got brokers who are there to facilitate all the sort of reputed brokers, SSY, Clarksons. They have got an FFA desk, so they can help you to get into this. So you don't have to really bother too much, or you need not have so much in-depth knowledge, and they can guide you quite well. The only problem in hedging is that you have to put in margin money, and it is typically 15 to 20% of your total exposure that you have in the business. Whereas for a physical risk, you don't have that margin money. But that's again not so much when you compare to the risk. FFA trade is getting very popular for last 5 to 6 years, and if you compare last year vis-a-vis this year traded volume, I think the increase is almost 60%. So that only shows that how popular hedging has become, especially the derivative hedging. And it is typically called FFA, forward freight agreement, and it is done on either options or on futures and options both. So you can opt for both, either future or options in the derivative market. So I think I've covered broadly. If any questions, I can always answer.
Fantastic, Captain Patnaik. I think that's like in a small session. You have given a fantastic overview. Just 2 points come from what you have talked about. That is, again, for the benefit of all the listeners, that derivatives, it's a double-edged sword, right? It could, if you don't do it properly, you would be losing on physical, and whatever underlying, that's the underlying physical, and then you have gone ahead and taken a position, you're losing there too. So the curves are moving, actually they are intersecting each other. The other very interesting point which you mentioned is discipline, in the sense that if you have hedged something, you must close a position when you have performed. If you get greedy that I'm going to make money, or market is in my favor, even though you have performed physical and you continue having a position open on derivatives, that sometimes could result in a problem. Thank you very much, both Alessio and Captain Patnaik. I think you have set the stage rather, now my lawyers can take us through the, how does the English law look at the entire thing. Now, welcome Sarah, Ian and Prederi. Mr. Justice Morrison, as early as in the year 2000, commented. It was obiter, it's not part of the law, that he, not the ratio. In Edix versus Arcadia, I can think of no sensible or commercial reason why the court should not take into account the cost of hedging instruments. Now, considering this, that almost 22 years ago, the gentleman said that, even now, people think that English law may not be supportive, or is it supportive of the hedging losses? Why is that? Let's start with Sarah and take us through that, please.
Well, Jagmeet, thank you so much to the Institute of Chartered Shipbrokers, Hong Kong, and to our sponsors and panelists. It's a delight to talk with you today about hedging losses, because the case that you mentioned is one with which we are very familiar, of course. I was the lawyer on one of the shortly after cases that developed the hedging law, which is the Prem Mala, which was Choil trading against Sahara Energy. Very interesting case where we continued the theme that you mentioned in terms of the necessity and normalcy of taking into account hedging losses. So just to start off with a few very straightforward principles to remind us the way it works in terms of hedging losses. Causation is your first legal principle. As a matter of English law, you've got to establish that clear link between the breach of the physical sale contract and the resulting hedging loss. And you're going to do that by careful preparation of evidence. And of course, in a more complex hedging dispute, you may have an expert who comes in to help with quantification of those hedging losses. Back in the day, when I worked with Shirag Kara QC on the Prem Mala, we had our star witness, who was the trader in the box, who set out in great detail the hedging losses to prove that element of causation. Now, the second important legal concept when proving hedging losses is remoteness. And here you're talking about that very familiar English law concept test of foreseeability. A loss will only be recoverable where it flows from the ordinary course of things, or where it is in the contemplation of the parties at the time of contracting. Now, in simple terms, the way hedging losses are factored in to a claim, if we use the Prem Mala, the Choil trading case, as an example, is you hedge at a certain moment in time, perhaps when you see your counterparty default, perhaps you were hedged already. In any event, as a prudent trader, you enter into a hedge as you enter into an insurance contract, because you know that the market moves, it's volatile, and you're not playing the market. Now, the purpose then of the hedge is to have a perfect hedge and to create a neutral effect to insulate yourself against the worst excesses of market movement. And what we set out in evidence, in a very detailed statement to demonstrate this to the English commercial court in the Prem Mala case, was exactly how each of those hedges was rolled over, and exactly how the particular hedges in respect of which loss was claimed related to the breach in question, which in that case involved the default of the buyer, meaning we held onto the cargo for longer than was expected. And of course, we also claim the ordinary measure of damages under the English Sale of Goods Act, being the difference between the market price at the time of delivery and where we ended up once we had performed our hedges and had a loss due to on sale price of a distressed cargo. Now, what was interesting about that case is when we went in, the judge said, well, I've had a look at these statements, and it seems to me, Mr. Cario QC, that all of these hedges have gone terribly wrong. And of course, the market had gone up, and as a consequence, the hedges had all resulted in a loss. So that was our first exercise to prove the losses, in fact, were directly related to the particular breach in question, which was, in this case, the need to roll over for an unexpected 3 months hedges to protect the position, to keep the position of the cargo neutral. And once that point had been understood, the judge also wanted to understand exactly how each hedge related back to the transaction in question, to the point where, in fact, one element of the hedging loss ended up being dismissed because we couldn't quite justify it sufficiently. The reason for that was because the trader in the box was not the trader who'd performed the deal. And so that just shows the extent to which it is necessary to prepare to make a very clear record and an early record of what has happened, because the real issue in hedging in terms of demonstrating that requirement of causation is being able to prove that particular losses actually result from the breach and from that deal, and not from playing the market, from playing a wider hedging book. Jagmeet, I think
Yes.
that probably is enough to get going.
Yeah, I mean, we can listen to it more, listen to you more about this. And so let's see, Ian, what do you think? Taking it further from where, even if something that you have to expand upon it, please feel free to do that.
Thank you, Jagmeet, for the invitation, and I'm grateful to speak with this panel this evening. Yeah, I guess coming back to your question, saying that you would think English law would be supportive of the recovery of hedging losses, and the question why traders, operators, and ship owners still have reason to doubt such recovery. I guess we're looking at two things, and if we kind of look at the evolution of hedging loss claims, one as a concept, are they potentially recoverable? And then the second part, which tends to be the more tricky part. I actually wanted to touch really briefly on a much earlier, it's actually an arbitration case in New York in 1994 called the Bonnie. And in that case, the tribunal looked at two things. They looked at the concept of whether, hedging in the context of, I think, petroleum products was desirable and an essential method of minimizing price fluctuations and exposure to loss. And they found that it was. And having, concluded that it was reasonably foreseeable that a charterer might suffer hedging losses, because in that case, I think there was a fire and there was a substantial delay in the delivery of the cargo. They then had to look at the actual hedging losses that were claimed, and they had to look at the transactions, and they had to look at how the hedges were placed and whether they were, tied to the actual physical element. And that tends to be one of the big problems. So, and I think by and large, there has been an evolution of English case law here. It's probably true to say that there's probably more authority out there, but by the nature of shipping and trade, a lot of these cases are in arbitration, so they're not published. So the ones by and large that we see, and the ones I think myself and my esteemed panelists have written on over the last 20 years, and the main ones that have been that are judgments that have been published, including Sarah's case. But I think from experience, we all know the hedging comes up a lot. It comes up in lots of different permutations. And touching on, I think, some of the points that Alessio and Captain said is, you know, where you're dealing with very sophisticated operators, where hedging, you know, where you have, you know, a very large machine at work. The tricky thing, and this is coming on to what Sarah said, the tricky thing is how do you actually separate those hedges out? And I know we have a question from Catherine Jago, who's a well-known expert in this field. This is actually one of the big challenges. And it's a very real challenge because actually trying to separate out those hedges and then prove them can be a very painful and very expensive exercise.
Yeah, thank you, Ian. Thank you, Frederic. Difficult one for you now.
You could say it's difficult, or you could say that I'm in the extremely luxurious position of coming in fifth. So much of the work has already been done for me. So I would reiterate, I suppose, then that while there is increasing clarity, and we've all written about this in various articles that the viewers can go and read for themselves, I think what really needs to be emphasized is that the recoverability of hedging losses does remain fact specific. We can set out the various rules and mitigation and the difficulties of unwinding a global book. But the reality is that every situation needs to be looked at on its own. And I would also say then, as an overarching principle, is that we must come back to compensation. The compensatory principle must underline all of this. And that what I mean there is that damages are meant to put an innocent party back into the position that they would have been in if the contract had been performed. And so this also flows to what you mentioned a moment ago, which is the 2x difficulty, that we can't be in a position where we're shooting for double recovery of losses under a physical and a paper transaction. And of course that can happen, or there's a risk of it, where you have a physical claim that's based under the Sale of Goods Act for a mark-to-market loss, being the difference between the contract price and the market price. And at the same time, you then have a claim on a hedge, which proceeds also on the basis of the difference between the sale and ultimate closeout price. So that's one difficulty. Equally, we've also seen many circumstances where there isn't an available market and you can claim both. And this can then increase the claim. And this was actually recognised, you quoted earlier, Jagmeet, Justice Morrison in ADAX. But we can also take Vitol and Beta as an example, where Vitol's claim was not based on a market measure, but was based on the actual loss. And in that case, despite a difficult market, it alleged that it could have made a profit on its physical sale had the biofuel been delivered. And at the same time, the hedge that it had put in place was imperfect. There wasn't a good paper market for biofuel. And so what they did was go out and sell gas oil. Now, over the life of the contract there, of the physical contract, the differential between the paper and the physical spread, so that it was actually then going to claim or receive a profit on the hedge. Now, in the event that claim ultimately failed for the reason that we are all of us coming back to, and Catherine notes in the commentary box, which is the difficulty of a global book and hedging that. But the principle stands that it can increase the loss. Now on that global book, and as I say, I find it interesting that we've all touched on it, that I have seen some people refer to global book hedging as being incorrect hedging. And I just wanted to take this opportunity to say that I think that mischaracterizes the position slightly. I don't think that it's fair to call it incorrect. Trafigura, Vitol, there's both cases with those players where that is fundamentally a key reason why their claims failed. But it's not that the hedges were incorrect. It's just that those players are so sophisticated, and Alessio touched on this as well, that it makes it very difficult to unwind those hedges after the event and connect the dots so that you connect a specific physical with a specific hedge. So that's sort of the key issue that we have there.
Thanks, Frederic. I think I will bring together what Alessio said and what you have said. When we say once the physical performing, the cargo has been performed, or the ship has been fixed, or the cargo has been sold, once that is done, it's not necessary that physically you go and unwind the position from the global book. When we say that the specific paper hedge for that physical position, for that particular transaction, you show it to be closed. And you may still have a live position in the book, which is then used or rolled over, or it is marked against another position. So I would like to hear from Alessio and Captain. Do you think it is something which is workable to use the hedge positions shown as closed against a performed physical transaction, and then rather than selling it and then buying it, or vice versa, letting the brokers make that 0. whatever percent, you actually use that position to allocate against another physical transaction? Alessio?
Yes, Jagmeet.
Yeah. So what I said is that if you have, let's take a practical example that you gave. Say you have 25 ships, all right? 25 ships
Right.
on 1 year, so 360 into 25, so X number of long days you have. And then let us say you have 10 million tons of cargo, convert them into the shipments, then you have the voyage duration, and you calculate so many days short you have, right?
Indeed.
You add them up,
Correct.
and you get a particular plus or minus. And if you are which I know you are, and you want to take a position in the market depending on the net positive or negative, long or short, you take a position in the market. Let's not get into options. So my question is that even if you have an entire global position, in the book itself, you may be able to set off a position which has been performed by taking the days from the global FFA book and close that position. Whereas you don't have to get out of the derivative position, but you use the derivative position against another physical position. So is it something that you do, or this is
Yes, we do.
possible?
No, it's doable. It's doable. It can be done also post case. But for us, because being a big book, 90 days here, 90 days, they don't change a lot our life path. But for a small company, for a small operating, it's more of an issue that they create much more nuance that he would do with us. And then if we go back a bit, I think it's very important for the audience to understand that cargoes are sold always below the FFA curve. So there is not there is no sugar vanilla. It's not a sugar vanilla business where there are free lunches given here and there. So a normal operator needs to be more creative towards the tool of FFA to make sense out of it. Because if normally you sell cargo below the curve and you buy physical tonnage above the curve, because as you mentioned, as the captain mentioned, the physical always deserves a premium over the FFA, because not many people have access to FFA because of these margin calls. So people are not, they don't have the right purpose and the right willingness to do that. So normally they hope to buy vessel on period, which deserves a premium. So you need to be more creative to create opportunity towards the FFA, when to buy or sell that particular case. So
Right.
In a normal line of business, you cannot sell the cargo, buy the FFA, or buy the vessel, because then you would lose money, right? So this is very important. You cannot execute your hedging the same day that you are buying or selling, buying a vessel or selling it, because then you would lock in a loss.
Right.
That's the big issue that you have, right? Even if you look at what operating day one, you sell a cargo, you buy a vessel, or you buy FFA, you lose, right? It would not make sense.
Yeah. Now coming to what Catherine also put in the question box, and what you have responded, and before that our legal experts have said. Even though you have a global book, and with the digitalization and all the software we have, is it possible to provide identification, unique identification number or UID to different positions, so they can be shown as married to each other? So it makes it easy for persons like Catherine to be able to identify and remove this earlier doubt that Sarah and Ian mentioned about remoteness. And so, is it possible to do it, or it's not practical?
It's definitely possible. Cargos, all of our cargos have ID number, and so are the vessels. The problem is the FFA. The FFA, they are not associated or linked to a particular cargo or a particular vessel. Because again, you would need a lot more accounting to do that. And if you do that, you would have also a better analysis of which cargo performed better or which vessel performed better. But unfortunately, in a big corporate, they are more focused on people making money than
Right. Now that's a very interesting point, Alessio, that physical hedging, it is possible to provide the ship days and the cargo days minus and then plus ship days. It's easy to provide name of the ship against the particular cargo, or voyage number of a ship against the cargo. But on FFAs, you're saying it is difficult to provide that sort of.
No, it's not difficult. It's pure matter of cost. It's not difficult at all. It's just a matter of cost. And again, in a big corporate, they.
Right. Captain, what do you think in your organization? Is it possible for you to provide that sort of link so that the issue of remoteness can be taken care of?
I think the whole concept of derivatives have evolved over a period of time. From a ship against a hedge or a cargo against a hedge to a global portfolio, which Alessio talks, are completely different subjects. And the strategy changes with the type of business you are in. And the strategy which Alessio will follow in COFCO may not be the same strategy what we'll follow. Maybe for me, it is ideal if I take a vessel on period charter for 90 days, I hedge it for 90 days against paper. But for Alessio, he has got global book of cargo. His hedging desk is separate. So hedging desk will tell him that I have got a Panamax for so many days available at so much a price. So you try to book your cargo, seeing that you don't lose out on this. So he'll be given at any point of time how much of exposure they have in the hedging market, a paper market, on a global book basis. So they will ensure that they are not overexposing themselves with the number of days available for a particular size of vessel, let's say Cape, Panamax, or Supramax. Right. So it is something like, so there are two different parallel desks working at any point of time. A cargo desk is busy booking his cargo. A paper desk is busy booking his own paper, so that they all share notes at the end of the day. But they just ensure that my exposure in paper is not far too high than my exposure on my cargo desk. So that's how it works. So it's very difficult to identify a particular number to FFA for a particular cargo booking. So that's number one. Number two, I mean, let's be very honest about it. When ultimately we all are representing commercial desks, we have to make money at the end of the day. If you really go a pure hedge, X against Y, you'll never make money.
Exactly. That's exactly my point.
What you gain in paper, you're going to lose in physical, or vice versa. But if you're a smart player, if you see the market is going down, you have bought paper or sold paper, kept it standby for a nice rosy day to come in. And then when you see you have got a paper at a very cheap price, then you take a position in a cargo, you tend to make money. So it is as complex as this. So as you evolve in your company, trying to do this, then you start devising methodologies for you how to give it a commercial angle rather than a risk mitigating angle. So the journey has gone from a risk management to a commercial angle. So let's be very, very honest about it. This is how it operates now. You ask Oldendorf, you ask Kofco, you ask Vitol, Louis Dreyfus. They will, at the end of the day, by hedging and doing physical use, so I've done zero profit, no company will be happy about it because you have done absolutely zero-sum gain.
Right.
But have you made money?
Yeah.
So see, I as a CEO or Alessio as a head of the cargo desk, he'll be asked, Alessio, how much money have you made at the end of the day? Fine, you have done your bottom side, you have checked it. Very, very good. But have you made a profit or not? So you'll have to play it very smartly. I hope I have answered your question quite well.
Yeah, absolutely. I think this is so useful for our lawyers also here. And I'm going to ask
100%.
I'm going to ask Sarah a question. Sarah, this is the situation, the arbitrage. You try and make money, you take that risk, but then the commercial guy comes to you that, this guy has defaulted and there's so much of money I've lost on the hedge, and you're not able to basically find out what derivatives is against which cargo, and there's a global book. So how would you help your clients? So how would you identify or try and sort out the issue about remoteness?
Exactly, Jamie. But I think this is the question that is troubling our experts. And hello to Catherine Yeager, who I see is asking us some very interesting questions. I think it would be quite unlikely in practice that you would end up with a hedging loss without being able to bring that back to a physical contract and a breach. And if that were the case, which is the question you pose, I do think if you couldn't link that back and you ended up with a global hedging loss due to a breach by a counterparty, you are going to have to prove to the English court that there is causation, that there is a sufficient link between the breach of contract that you're talking about and the loss that you've suffered on your global book. And you will also have to satisfy the English law test of remoteness, which is, of course, that you are only going to recover hedging losses or any losses where it flows from the ordinary course of things or is in the contemplation of the parties at the time of contracting. So if you can't satisfy the relevant English law test, you're going to struggle. On the other hand, I think our discussion, and especially some of the comments from Captain Patnik, are very helpful because they highlight the purpose, of course, of the English Sale of Goods Act, which, as mentioned by Praderi, is to compensate on the basis of the mark-to-market contract versus market price in the first instance. And when we talk about hedging losses, as was established in the Choil case, the Prem Mala case I spoke of, to bring into account any losses or gains into that standard measure of damages and net them out, so that we see, for example, in the Choil case, we suffered losses on the hedge that we wanted to bring into the picture to set off against physical gains. So we ended up with a net claim against our counterpart. Now, the other side to that coin is, of course, where you have physical losses and you have gains on your hedge, and that's the case of Glencore and Trans World, where we have the court holding that damages for physical loss were offset by physical loss was offset by the hedging gains, and that had to be taken into account. So looking at it from a global book basis, I would be dubious that any court would want to intervene and step into a situation where you have a rather complex game being played by a trader, or even a situation where a trader says, look, we really can show you, we can show that we took some strategic decisions on our hedging, and that was because the market moved a certain way and there was this breach by our counterparty. The reason being, I think you have to ask yourself whether that is going to satisfy the English law test of remoteness. Is that going to reasonably, in the contemplation of the parties at the time of contracting?
So yeah, thanks a lot, Sarah, on that. Now you talked about at the time of contracting. So let me go to Ian and ask him. At the time of contracting, you see the negotiations take place depending on the bargaining power of the individual parties. So what about having some express term being incorporated in the contract regarding hedging losses? Can you guide our commercial people and the participants? What are the different options that you might have?
In terms of making those recoverable or not excluding them. So I guess,
It could be both ways, depends which side you're from. Yeah.
So I guess this has evolved over time. I think probably maybe 30 years or so ago, there was probably less familiarity in terms of hedging outside of traders. I think the first cases obviously identified that it was pretty difficult for one trader to argue against another that losses weren't probably, hedging was not within the contemplation of the parties, bearing in mind it's pretty commonplace. Where the issues became more distinct was where you were dealing perhaps with a ship owner and a charterer, and the charterer is a trader. And do ship owners and traders operate in the same way? Now, I think obviously we've seen over time that shipping companies have become more sophisticated, and I think with global trends and with massive fluctuations in freight and other things, then obviously I think ship owners have had to adapt, and to stay viable, have had to deploy risk management tools and derivatives. So those are more commonly accepted, I think, nowadays. So your baseline has changed. So I think the baseline has become a little bit more flat across shipping and trade in terms of hedging as a concept. I guess if you're looking at defending claims and you're looking at trying not to be on the receiving end of potential hedging losses, then there is certainly the option in certain circumstances to include carefully, I would say very carefully worded exclusion clauses, and some companies do that as a matter of course. If you look at some of the big majors, BP and others, they have fairly tightly worded exclusion clauses, and certainly, as a matter of practice, we have seen that increasingly more common now as a request, I think, commercially. Unfortunately, particularly if somebody's been on the receiving end of having to pay out on a hedging loss claim. So that's certainly something to bear in mind in terms of protecting yourself, but it can be quite difficult depending on where that negotiating strength lies. So sometimes you may not be able to put something in that contract. So yeah. Then you may be hopefully relying on the fact that you have a big sophisticated counterparty that has a global book, and they will struggle to unpick the individual hedges and tie them to the breach and the physical. So yeah, I think you have to kind of go in with your eyes open a little bit.
Absolutely. And unless of course it's the practice of the trade, and it's goes without saying that hedging would be done. Now coming to Predery, in terms of a party trying to tell you, oh, but you should have hedged. You have not hedged. So the losses which you're claiming against me is not because of my breach, is because you did not hedge. What would you say to that?
Well, I think you're right that there is certainly an obligation to mitigate, and so you could look at it from the perspective of the party in default. Now, we see a few different arguments being deployed here, and one is the mitigation point that I'll come to in a moment. But the other is essentially when the party in default is faced with a claim for hedging risk, for hedging losses. And at that point, I do have some sympathy insofar as it is perhaps painful to be pinged with a loss for a claim arising out of a hedge that you never were party to, that you did not agree to, and yet was perhaps foreseeable. So I think I do have some sympathy there. And perhaps even when we think of oil majors and we know that they will hedge, we don't know exactly what they've done. And so I think this comes back ultimately to Sarah's point, which is that English law says that you must look at the transaction as a whole. And as we mentioned earlier, the physical transaction and the paper transaction have to be closely linked in order to be recoverable. But then if we look at the mitigation point, it is now reasonably understood that as soon as you accept a repudiatory breach, you come under some, it is not a heavy burden, but you come under a burden to mitigate your loss. And at that point, I think it may have been in Choyle, but I'm sure Sarah will correct me if I'm wrong, where they actually argued that the hedge should have been put in place quicker. And a good example is also Glencore, where they put in place their hedge in mitigation, but then tried to assert that actually that was their own action, and they should not have to share the benefit of it. They should be able to claim the market loss on the date of delivery. Now that increased their claim to, I think, 11 million or something like that, when in fact the hedge was unwound at 8. And of course, in that situation, the question was this actually done in mitigation? And the court found yes, it was. So there is a duty to mitigate. If a hedge is reasonable, then you should do so. It's a light burden, as I mentioned.
Thank you. Thanks a lot, Predery. Sarah, just a quick question, follow-up question to you on what Predery said. Now, for the innocent party, is it fair to expect them to take a hedge position when there is no simple hedge position available? It's very complicated. It requires a lot of expertise. You need to have 4 people doing calculations for you to do the hedge. Is it first of all, that somebody has breached, somebody has run away, and you're losing, and then you are being expected to take a very complex hedge? What do you say?
Very interesting query, Jagmeet. I think at the moment, I do not believe that the English commercial court would hold that a failure to hedge means that the loss is not caused by the breach of contract, because I think that is just so basic to English law. If you look at the Sale of Goods Act, it's all about the mark-to-market loss, and that's the prima facie measure of damages, and that's ingrained in years of judgments. Hedging is a relatively new concept, as we've noted, and it's really only the last 20 or so years that it's become quite clear law that hedging losses under certain circumstances where they satisfy the tests we've mentioned are recoverable. So I think the answer is no, you're not going to be required at the moment to hedge. Although, as we look forward with the evolution of case law, certainly you can foresee that as a part of a perhaps claim or defence, that where hedging was not done and should have been done, that it should have been done. And how the court would deal with that, well, they would ask an expert to quantify what hedging losses would have, or gains would have been made. But ultimately, I think it's, we have to remember that what you're really talking about here is adding an additional burden on a claimant who has suffered a loss. And of course, it lies ill in the mouth of the person, the company who has caused damage, to say that mitigation strategies were insufficient or were done badly. And I think that would include a decision not to enter into hedging losses, even in a sophisticated market, although of course in practice, sophisticated traders will hedge. And of course, that is what we tend to see.
Right. Thanks, Sarah. I think next question is, we don't have a lot of time. So the next question is to anyone who can answer first, and then you can follow up with second and third. We have been talking about experts. We have been talking about what needs to be done. So can you throw some light on the evidence part, collecting evidence, how to make sure that, I always believe as an arbitrator, the quality of evidence is extremely important. So what sort of guidance would you give to the commercial people with regards to importance of experts, witness statements, what sort of evidence? So let's start with, okay, I'm leaving it to you. So you decide.
I think, if you start from the beginning, you've got to start, we say everything must tie to your physical transaction. So, before you get into your experts, you've got to get your foundation right. And certainly I think as lawyers, we spend a lot of time, talking to the trader or the desk and understanding kind of the transaction, what you did, what you didn't do at particular, from the beginning of the transaction and then around the period when the breach occurred and what was happening in the market, and particularly if they've hedged or closed out positions or partially closed out positions. So one is really kind of mapping out the whole transaction and gathering all the information, because with the greatest will in the world, experts can only work with data that is provided to them by the client. So that's the key, I think, at the start. And then you get into the experts. I'll pass this on to Sarah and Praderai to speak about the expert angle.
I think you're absolutely right. A good expert is worth their weight in gold. But it's also got to be an expert that actually is a specialist in hedging, if that is what you are talking about at this time. And so it's a shame that Catherine isn't able to speak at this point, but she has been quoted in one of the judgments as saying, well, if we're going to be talking about hedging, we really ought to have a specialist on hedging. And I don't think that's particularly surprising. So I think getting a good expert and getting them in quickly and early is essential, because it helps you unravel everything and understand your case.
Sarah?
Excellent. Look, I did write a little article on this, which Jagmeet, you kindly forwarded, and really to summarise the points made there, you need to make an early record of what happened. That includes getting full disclosure to demonstrate the hedges that occurred. And it's a good idea to get cracking early on the preparation of witness statements, so you don't end up, as we did in the Prem Mala, preparing an additional statement overnight on day 2 of the trial, as requested by the judge, to clarify further details of the hedging losses. That was great fun, and there was a lot of action in that case, but we did end up winning on that statement. So part of the difficulty was that the documents were only received a little later due to the fact that a third party held them in storage. So it is all about preparation, working with an experienced expert. And I agree with what the panelists have said. It's great to have an expert such as Catherine Yago involved, because of course she is very sophisticated in her knowledge, and it's a very detailed mathematical exercise quantifying hedging losses.
Right. Thank you, Sarah. Now I come to Captain and Alessio. Whenever we talk about evidence, whenever we talk about doing things right from the beginning, I think the awareness is very important. Knowledge is very important. I mean, when people who are involved in taking positions, who are involved in looking at mark-to-market, etc., I think that is very important. Captain, what do you think? Anything else you would like to add to what Sarah, Praderi, and Ian have said from commercial perspective?
No, so as I said, it's very clear. So I think English law looks at things very favorably when you can prove that, yes, you have actually suffered a loss because of a business transaction. But they're not going to look at it favorably if you just say that you have done multiple things and then you try to link your one transaction to the multiple things that you do. So I think that's very clear. I'll give an example from the physical side. If you have taken a vessel on period charter for a COA and the counterparty default, there's some noise. So if you have taken a vessel on period and the counterparty defaults the COA contract, then you can exhibit that, yes, you have to fix this vessel, the market has fallen at a loss for the remaining period, then you are definitely going to get compensated as your losses. But if you've taken multiple vessels on period and you've got one COA, two COAs running, so multiple vessels give a 500 ship days, whereas the two COAs give 200 ship days, then how are you going to link it? You cannot link it. So then I think it will be very difficult for you to prove that this particular transaction made so much loss and then you claim for it. I think the law is very clear to my mind. As long as you have actually suffered a loss because of a transaction which involves hedging, and you can prove that very clearly, English law is going to look at it very favorably. But you have done multiple things like big players do, and then you try to link it with one particular transaction, I think then your case is very weak.
It's challenging. I won't say weak, I would say it's very challenging. And that's where you need good lawyers who can put things regarding causation and the remoteness and mitigation in place. Alessio, any comments from your side? You're muted, my friend.
Sure, Jagmeet. No, I would agree with Captain said before. Yeah, I think it's a bit more complex than just buying the vessel and selling the cargoes because of its timing. So,
right. So what we are going to do now is, thanks, Alessio. What we are going to, I'm going to quickly have a look at the questions which have been asked. I think Catherine's question, thank you, Catherine, for a very interesting question right in the beginning of the webinar. And we have tried to address it as much as possible. I hope it is good for that. And then we have a question from Edwin. Having heard from the panel the many horror stories, should not the hedging participants be pre-qualified to do hedging on exchanges by compulsory training courses that must be passed by examination? We can use the same comparison as Institute of Chartered Shipbrokers. I think my question reply would be that yes, definitely, in terms of knowledge, education, learning, awareness is important. Whether to have a qualifying certificate like the insurers have and the other dealers have, I'm not very sure. What do you think, Frederick? Do we need a subject in the ICS to do hedging, and only then you should be allowed to do hedging?
personally disagree. I don't think that it's necessary to have a qualification. I think it would be advisable to certainly have some training, but I think really for our present purposes, in terms of trying to get some certainty about the recoverability, I think it's much more a big picture policy issue for the companies as a whole, and to clarify for themselves when they are seeking to hedge risk and when they are seeking to speculate. And I think we need to be very clear on that point rather than put in place barriers before people can hedge.
Right. And there's another question from Catherine. I think that's an observation. You have gone from hedging to speculation, which is not relevant to claims. You're absolutely right, Catherine. So what was actually mentioned was the commercial perspective, not to deal with the claims, but this is how the commercial people would like to arbitrage and make money. But I fully agree with you that speculation must be separated from the hedging loss and profit, because it's only going to make your claim weak. If it is found that it's not hedging, then what hedging losses are we talking about? Okay, then we have another one from Chris Halpern. Can a hedge be considered mitigation at all, since it can make or lose money? It's easy to judge ex post facto, but not at the moment the hedge is made or not made. I think a fantastic question. And I would like to start with Sarah, and then coming to Ian and Prederi, and then our commercial experts. You can read the question, right?
Okay. Yes, Jamie, the key question I think was whether we can consider hedging following a breach of contract of sale reasonable mitigation. Yes, I mean, I think the English Commercial Court has absolutely confirmed that hedging is generally speaking, if it's obviously, it depends on whether the hedging itself is reasonable, falls within the tests of causation and remoteness. That if you're let's say doing something which the market would consider normal in terms of protecting your position against market movement, then yes, it's going to be mitigation of any losses. And the other side to that coin is any gains have to be taken into account in terms of the way your claim is made. Is that it's the sort of dichotomy between the Choil case, where there were losses, and the I think it was the Vitol case where there were gains, and both have to be taken into account. If you make a loss on your physical and you have an equal and opposite corresponding gain on your hedge, well, you've got to net out the position. That's what the court has said it a number of times, and any tricky arguments to get around that one are, I think, unlikely to succeed. The more interesting questions, which I think we have looked at already, include whether or not there's an obligation to hedge. I think the answer there is almost certainly not. And then another very interesting issue that we were touching on, I think, Ian and Roderia in our recent chat, is whether or not the law looking ahead is likely to change in terms of hedging, and particularly the case of MSC. The case really involved a dismissal. It was Traffic Bureau versus MSC. What the judge held there was that there was no evidence that MSC would reasonably foresee that if there were a breach, and here we were talking about misdelivery, so perhaps a little bit unforeseeable in terms of the facts, that the shipper would hedge. So because MSC were owners, they were taken not to have been expected to foresee those losses. Now, my question for all of us is that position likely to change? I think it could well be that for a worldwide ship owner, the suggestion that it's not reasonably foreseeable that a shipper would hedge might be something that might change, and a different position might be taken by the commercial court in years to come. That would be my prediction.
Sarah, you're talking about that case where it was copper in the containers, right? So let me take it forward and ask Ian about that. Suppose it was a bulk carrier or a tanker. How would the entire thing change? Would the foreseeability
Okay.
change?
I guess the tricky thing is are the courts going to look at hedging specific to commodities? Hard to say. At the end of the day, if you're looking at trade, I mean, shipping and ship owners move all sorts of cargoes and commodities. And I think probably what we were discussing is probably because of the increased sophistication and the fact that ship owners themselves are more likely to use derivatives and hedging as a risk mitigant tool themselves, it becomes much harder to run that argument, as a foundation point. I think we're still going to have, I think the difficulty or the tricky thing is still going to be about looking more closely at the hedge itself and what was done and the reasonableness. So the concept of hedging, is going to be there, but it's really kind of drilling into the detail, I think, of what transpired and whether the hedge was reasonable. And there is authority, on the Bonney, they actually looked, they looked at hedging as a concept. They said it's not outside of the norm. But what they then looked at was the hedges that were done, and they looked at the typical hedging strategy of that party, and they found that there was quite a distinction between the two. And in those circumstances, the hedging losses there weren't recoverable. So partly, I suspect there'll be a little bit more of a probe into, what is the hedging strategy? And this is something that comes up quite often, I think, in cases nowadays, where companies have annual publications and web content, and they will talk about risk mitigants and hedging strategies and whatever, and it can quite often be quite a fertile ground for lawyers to probe the hedging that they did and compare and contrast it with the strategy that they tell the world that they do. So I think those are still going to be fertile grounds for argument.
Okay.
Certainly, I think hedging losses are always. I don't foresee they're going to become easier to prove, but it may be that I think some of the initial hurdles may be diminished, I think, over time, as within trade and shipping, there's more familiarity with hedging and the use of derivatives, I think.
Yeah. Coming to you, Frederic, there's a clarification from Chris. Let me qualify by saying that I meant that failure to hedge would be a failure to mitigate. What do you say to that?
So I think if we bring it back to sort of first principles, if it would be reasonable
just
to
very
mitigate,
very briefly, if you can.
If it would be reasonable to mitigate, then you should do so. If it is complicated, if it's imperfect, the burden is not significant, then no, you are not expected to mitigate. It is very much a question of whether it would be reasonable to do so. That's ultimately the answer. So if a hedge is straightforward, if you are an oil major, I think you probably would be expected to do so.
Yeah. Okay, then there is the last one. I think, Catherine, I will quickly answer that. Yes, MSC case was the copper in the containers, and there was some issue about malpractice, and the cargo was bills of lading were tampered with, fraudulent. Yes, that was the issue. Now we just got 1 minute, so I don't want to exceed time. So I will take that 1 minute to thank all my panelists. Thank you so much, Sarah, Frederic, Ian, Alessio, and last but definitely not the least, my dear friend, Captain Patnaik. Thank you so very much. And each and every one of the participants who took out time and you have been with us. Thank you so much. Really appreciate your joining us today. It's always a learning every webinar is a learning process, and it's so beautiful. So just to tell you that on the 21st of July, something that Captain mentioned about derivatives, a double-edged sword, etc. So we are going to have a webinar on a very similar topic, which is called derivatives. Is it hedging or taking another exposure? So we discussed a little bit from there, and we will go deeper into it. And we got Johnny B on the panel. Johnny B is, what's his name? That's not very easy to pronounce. Banaskevich. So we have Mr. John Banaskevich, who is the Managing Director and CEO of FIS. Then we are also going to have Richard Hayes or Vivek Nafre, one of them. They are Managing Director of Clarkson's FFA, Futures Desk. And then we are going to have one gentleman from the commodity house talking about derivatives, how they do, and the other one from an operating house. So that would be nice. So please, I will circulate this, and I look forward to seeing everyone again. And on behalf of the Indian Maritime University and the Hong Kong branch of the Institute of Chartered Shipbrokers, thank you so much to all my panelists and all the participants. Thank you so much. Bye.
Thank you.
Pleasure,
Pleasure,
Jackie.
Jackie.
Thank you all.
Thank
Have a
you.
lovely
Thank you.
evening.
Bye-bye.
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 Goodbye.
Thank you.